Hi, my name is Eric Terry, NP Weiss Law, family law guy. You know me, I'm not dressed in a suit today, but I'm going to talk to you anyway about things that if you do in your family law case, they're really scary. So scary that they're important enough to bring up just before Halloween. So, number one, not telling your attorney about a fact that is bad for your case. Oh, this is huge. I can't tell you how many clients I've had over the course of my career that either they're embarrassed by a fact or they don't think it's that important or they hope it just slides by the wayside, what have you. But I need to know everything when I sit down with you early on in the case to look at your matter. If you don't tell me something that is bad for your case and I have no reason to look for it, and I find out that fact midstream or even worse, right before trial, good luck to you, man. Because I'm telling you right now, I have wasted more time and more of my clients' money prepping for a trial, litigating an entire case to find out it was all a waste because whatever bad fact screwed it all up. The one that, immediately jumps to mind is not telling your attorney about poor use of money when you are asking the court to reduce your child or spousal support obligation. If the other side can prove that you make incredibly poor financial decisions and waste your money, and that in turn, that demonstration of you wasting your money shows that you have more money than you're letting on, you've just tanked your entire representation. And you've spent how much money on me getting the thing ready to go, prepping for trial, prepping you for trial, developing all the exhibits, creating the trial binder. Why? Just tell me early on. If you have a criminal conviction that is drug related, child related, like a child endangering, or domestic violence related, or even just assault related, any violent crime, what have you, tell me. If it's out of state, particularly, because I might not be able to find it, even with my search engines, if it's out of state. And if the other side knows about it and they bring it up, you better believe it's going to be important at trial. And so if you tell me early on, I can advise you, number one, appropriately, what your chances are. And number two, if I think you still can win or even get some of the relief you want, I have to plan for it. I have to be ready for how to argue against that point. It's better if I plan for it. I get this a lot in cases where somebody will look up shared parenting. And of course, it immediately translates to them 50-50 parenting. And then they know more about it than I do, that they're entitled to this thing because they read it in a story somewhere, or they heard it from their friend. Well, my friend got this, so I'm entitled to this. Maybe, but maybe not. Every case is a little bit different. And every court already has its idiosyncrasies. Even if had the same family and went to court in Cuyahoga County and got one of those magistrates, I might get a slightly different result than if I had the same family in Geauga County or in Medina County. The magistrates themselves are all individual people. They focus on different things and they have discretion. So you're going to get slightly different results, sometimes significantly different results, depending on what court you're in. But also, and I think this is the greater thing that people don't take into consideration, it's not your status as father or mother that necessarily matters. It's you. The court is looking at you as a person. They're teasing out your personality traits. They're teasing out your stability and your responsibility. They're teasing out how level-headed you are in the sense of when challenges arise, how do you respond to those challenges? That, more than anything, is going to inform the court's decision about who gets custody, who gets residential parent for school purposes, who's going to have how much parenting time, how much we can trust them with various tasks, who's going to take the kid to the doctor's office, who's going to be the the level-headed parent when it comes to making medical decisions for their children, because they're the only ones making the decision. So they don't want the one who's just out to get the X making those decisions. They want the one who's thinking about the kid. And I know every single parent out there, every single one of you right now is saying, I think about my kid, but trust me, the court's trying to figure out which one of you is more likely to make that decision in a level-headed manner. It's important for you to remember that every case has a little of those nuances that you're not going to see when you just Google somebody else's story. And so you can't just assume because I looked up a legal term or I looked up somebody else's experience in the family court system, that mine is going to be exactly the same way. It's just simply not true. A lot of times, and this is going to get a little bit in the weeds if you've never watched any of my videos before, but there's a thing in family court cases and civil court cases generally called discovery. It's a list of questions. You're going to have to gather a bunch of documents. Nobody wants to do it. You're going to have to get on all your bank accounts. You're going to have to download all the statements. But I'll tell you what, it's one of those things that the court's looking at to see who's the responsible person. Who's the responsible parent? Who's going to comply with court deadlines, right? So, every case, you're going to have some manner of disclosure of documents and answering questions. It's going to happen. And the court's going to have a deadline for it on some manner, right? Either they're going to have a mandatory disclosure order like we have in Cuyahoga County, where they say right off the rip, here's 13 things each party's got to get together and give to the other side. If you do that, you look like a superhero, especially if you're on time. If you do it a little bit late, probably they don't care. If you don't do it for 5 months, good luck to you, because now you look like, you're just blowing it off. And as silly as it is, if they issue a support order for you, pay it on time, no matter how hard it is and how unjust you think it is, because this stuff adds up over the course of the case. So you really need to consider how you conduct your life, because that stuff can come into court. And if you want to be perceived as the responsible, reliable parent, those things add up. You want to follow court orders. You want to make sure you are meeting deadlines. All right. So the other one that happens with missing deadlines, I can't tell you how many times I've had a client come to me 3 days before trial with an exhibit. Here you go. But we are required, depends on the court, either a week or 2 weeks before trial, we have to have an exhibit list. And that has to be filed. And then there is a disclosure requirement. There are no surprises. There are no surprises in civil litigation. Let me say that again. There are no surprises in civil litigation. You are not allowed to ambush the other side. You're just not allowed. So if you are going to try to surprise, like on all the movies, and here's all this evidence, and the other side hasn't seen it, we're going to surprise them in the courtroom. No, they will not allow you to bring that evidence in. The court is not going to consider it. It's going to be objected to. It's going to be excluded. That's it, right? There's a slight exception to that gets way into the legal weeds on impeachment. Trust me, impeachment is your last resort. You don't want to go that route. You want to disclose everything up front, have your arguments ready. Trust me, we've all seen it all before. Nobody is truly surprised by the kinds of evidence you're going to bring. But the specific exhibit has to be disclosed well enough ahead of time that the other side is prepared for it and can make an argument against it. Same with us. We expect it too. You don't want to be surprised. You don't want the other side trying to pull that kind of stuff on you either. And so give your attorney all the exhibits you intend to offer well in advance of trial. I understand very well. This is family law. Family law based on emotions on some level. You get married to somebody because you love them, at least presumably. And that's an emotion. You might come to hate them, and that is an emotion. I understand all of that. It is natural for people in the phase of life where their relationship is ending to have emotions. That's fine. Save it for your therapist. For a number of different reasons. I didn't go to school to be a psychologist or a counselor. I don't know how to advise you about your emotions. That's not what I went to school to train for. Somebody else did, and they should be the person that advises you on that front. But also, I'm usually twice the cost of those people. And so if you tell me those things, you're just spending twice as much money for half of the results. So it's unwise, in my opinion. But in addition, my purpose, if you will, is to sift through the emotions from my client and from the other side and try to come up with a logical game plan to get you what you want out of the family law case. And as a result of that, I'm going to advise you from a logical, strategic perspective on your case. And if you filter that through your emotions and then tell me, no, I don't want to follow your advice because I just want to hurt them, best of luck to you, because that might be viewed by the court as an unreasonable decision, as one driven from emotion. And then again, to go back to a previous point, can I trust this person to make the logical, sober decision when in the future, when I'm not looking at them, when it involves the best interests of their children? And so it is very important for you to kind of compartmentalize the emotions in a separate place as much as you can. And trust me, I get it. That you're going to have some of that when you're talking to me. But at the same time, we should focus on the logic. It's going to be better for your pocketbook, and it's going to be better for the ultimate result in your case. Failing to consider optics. And we've talked about this a little bit already. Again, to go to the discretion of the trial court. I had a magistrate tell me once, they were teasing me in particular, that you don't understand, Mr. Cherry, that really when you come to court, I know you're an awesome attorney, but I really pay more attention to the clients than I do to you. You're like 20% of my decision, if that. The client is 80%. And, after I got over my emotions of feeling inadequate, I told, yeah, of course the magistrate's correct. It should be about the client and not about me. I'm just helping them, guide them through and present a good case, right? That's all I really can do at the end of the day. But if you, as the client, operate your life and show up in court in a way that is, let's say, aggressive, unreasonable, irritable, disrespectful, those things can filter through to a judge or a magistrate, and then they may decide poorly in your case because of how they view you as a person. And I'll give you some specific examples. Social media. Be very careful about social media. When you're in the middle of a family case, you don't need to put out your dirty laundry. I know you probably want to have somebody to hear you go through your struggles, and it helps you process your emotions, to share it with somebody. That's perfectly fine. Do it privately. Find your friends, meet them for coffee, go out, get something to eat, and get it out. Get your advice from your friends in a private manner. You put stuff online, might show up in court, and that might backfire against you. And then tenor in the courtroom. You show up in the courtroom and you're, that's may convince a magistrate that you're an aggressive person. Speaking over a judge, bad idea. That, I can't believe it happens as often as it does, but it does. And so, if you get combative in the wrong way in the courtroom, it's going to backfire on you. I usually tell my clients, like, you be on your best behavior. Let me be the jerk. Let me go in there and argue with the judge, argue with opposing counsel, cross-examine the other parent in an aggressive manner, because I'm not the one interviewing for parent. I can be the person to, try to get the other side to be emotional. I can try to get the disclosure from them that is bad for their case. I can argue with opposing counsel about particular legal issues or pieces of evidence, what have you, in an aggressive manner, because that's my job. And the court knows that. But you have to be, so yeah, don't be scary in your family court case.